Are you ready?
I am ready.
All right.
Thank you, Deputy Chief Justice.
Good afternoon, Judge Steyn.
Good afternoon, Deputy Chief
How are
Justice.
you?
Well, I was hoping to say good morning, but no.
Indeed, we owe you an apology for
No,
keeping you
no,
waiting.
no, not at all. I know it's without, it goes beyond everything
Yeah.
one can do. These things are not predictable, so yes, I'm
Thank you
fine.
for your understanding. All right. You hold 3 degrees, a BUris, LLB, and LLM.
That is correct.
All right. You joined the Department of Justice in 1980 already.
That is also correct.
You must have been fresh from high school?
It was in my year I finished matric. I think the results came out on the 16th of December, and on the 20th of December 1980, I exchanged my school uniform for work clothes, and I worked behind the counter of the maintenance court, yes.
So you really started at the very bottom rank. And you were with the department until 1995.
That is correct.
What did you do in that 15-year period?
In the 15-year period, I have been, starting off in 1980, I've been every clerk you can think of in the magistrates' court, or imagine even. And thereafter, I qualified in 83, so in 84 I became a prosecutor. I prosecuted, I worked through the ranks, I was promoted to being senior prosecutor. I've also then been appointed as a magistrate, and I've been in the court, various magisterial districts for about 4 years, plus minus, a little bit longer, because you start acting before, when you're still prosecuting, they use you on the bench. And thereafter, I went back to the prosecution after being asked by the then Attorney General to come and train prosecutors. So I've made the jump back from magistrate to prosecution in 1992, and I then led very big court, Weinberg Court, where you had a complement of about 38 staff. In 1995, I was headhunted by UCT and then left.
So you did all your studies part-time while you were working?
All of my studies I did part-time, yes. I have never been full-time to a university at all.
Well, and it appears that you would have done exceedingly well, because you were snapped by UCT.
Thank you, Deputy Chief Justice.
You were a senior lecturer at the University of Cape Town for what, 9 years?
I've been there for 12 years. I joined UCT in 1996. I left UCT by December 2007. Strictly speaking, I was still employed by UCT when they granted me the opportunity to go and act as a judge in the Western Cape High Court.
And that was in 2008?
2008, I was given that opportunity.
And your permanent appointment was in 2009?
The 1st of January 2009.
All right.
Yes, Deputy Chief Justice.
You have written a number of a whole lot of judgments through your judicial stint, and I just wanted to find out if you were able to produce 1 or 2 during your acting stint at the Constitutional Court?
In fact, in the Constitutional Court?
Yes.
No. I think that is, I'm very glad that you referred to that. There's only one of the comments, I think it was the law teachers that referred to an acting stint in the Con Court. I have not acted in the Con Court, Deputy Chief Justice.
I wondered, because
I think
it
was a confusion between me and Judge
other...
Madondo, who had the opportunity to act in 2021.
No, there is another Judge Steyn who acted there, so they must have confused you with her.
There is an Elise Steyn in the Western Cape, yes. Okay.
All right. But you did manage to produce a good deal of written judgments in the High Court, nonetheless.
Yeah, in my year of acting at the Western Cape, 3 of the judgments that I produced were reported in the law books, yes.
and you don't delay your judgments. You have a certain reputation of being very hardworking and efficient.
Yeah, I don't believe in it. I think it's a slippery slope. Once you delay the judgment writing, you never catch up again. During my time of studying, I think one of the lecturers at Justice College always reminded us, you have no excuse not to study. On a Saturday there's 14 hours, and on a Sunday there's 14 hours, so 28 hours, and that goes also for your work.
You had occasion to serve as the Vice Chairperson of the National Council for Correctional Services, and you later became its Chairperson.
That is also correct, Deputy
How
Chief
long
Justice.
were you with that body?
I was there from 2015 until October 2019, so that was for a period more than almost 5 years.
Well, the comment, even from those who don't support your candidature, is that you did very well there. What exactly did you achieve? What is this tremendous achievement that everybody is talking about?
Well, can I perhaps just enlighten the Commission? The National Council of Correctional Services is really a very difficult body to chair. You consist, and the Minister knows best about this, that of a group of members that come from various backgrounds, different disciplines, psychologists, you have at the same time people from correctional services, you have community members, and you have experts in the field of prison law. So we come from different backgrounds and cultures, and it was a tricky horse to ride at times, because you have to convince everyone that a certain person who serves a life imprisonment is either ready and reformed to go out, particularly in certain instances, you also have to reprimand members if they were not pulling their weight. It is a lot of reading. Some of those profiles is easily between 100 to 250 pages, and at times we've done 150 in 1 week. So yeah, that was... In the end, when I left, what made me feel good is that when we handed over to Judge Desai, he had a well-oiled machine, and we worked harmoniously as a group.
Wow. All right. Let's not waste any more time. You are competing with Judges Madondo and Boyodroati for the leadership position in the KZN division of the High Court.
That is correct.
Why should the JSC choose you over them? What do you have to offer? What plan do you have for that division, if any? Well,
if the Commission allows me, I will go straight over to my vision for the division before presenting anything else as to what formed and shaped me before I get to this point. Let me just start off by saying, Deputy Chief Justice, that whomever gets appointed of the three of us will have to have as a primary focus to reunite us as judges and get us all to work as a team again. I firmly ascribe to a team spirit in people that I lead. And my first vision for the KwaZulu-Natal division is to transform it back to an efficient division, delivering justice timelessly and also serving the public. Second issue that I consider as a vision is the issue that is paramount to any judge president's heart, and that is acting judges. You have a constitutional obligation, and in order to see to it that you have a pool of acting judges that are capable and competent, you must make sure that those candidates can be identified. Now, the way that we've always worked is we do have an acting judges committee whereby individual candidates will be evaluated, and we will make recommendations to the judge president and the deputy judge president as to who's suitable. So in my view, You should go further as the judge president because you have the opportunity to liaise and consult with bodies like the Black Lawyers Association, NADEL, the Society of Advocates, and also the Legal Practice Council, but also the law faculty. In that regard, you would be able to at least make sure. I understand that previously there was indeed a protocol in place, and the erstwhile judge president have liaised with both Advocate Skinner from Society of Advocates as well as Advocate Ghani in Maritzburg, that candidates will, if there are anyone from the bar, that people will be consulted. Now, I think it's very important that consultation takes place when you invite people to the bench. The third vision that is very close to my heart is the vision of gender diversity. Presently, in the complement of KwaZulu-Natal, we have 28 permanent judges. Those are the judges that fill the position presently, and 11 of them are women, 17 men. I would be thrilled when we reach the point where we would be equal in number. The fourth vision is that you as a leader should never work in isolation. We are a collective, and as the judge president, you should not make decisions in a silo. When you have to collaborate with colleagues, and that does not mean, please, I just want to be respectfully say, that does not mean that the decisions must be made by everyone else. The day-to-day running of the division, the administration, judges should not be burdened with that. That should be the work of the judge president and also the deputy judge president. My fifth vision, which is perhaps very equal to the other visions I have listed here, is communication. Since the appointment of the office manager in KwaZulu-Natal, the communication has improved, but there is definitely a great scope for improvement. The manager is also just as strong as anything that is communicated to her. So it is very important that the judge president makes use of a good communication system, and through that, intertwined, is that judges should meet on a regular basis. In fact, since January 2022, we have not had a single meeting. And at times there are things that are important to discuss because it impacts on the work of the judges. So my vision is that one should be hands-on and you should meet with colleagues, debate and discuss issues so that you can move forward. 6 is, for me, which I also consider highly important, is that the distribution of work should be equitable and fair, and work should be allocated and assigned to judges timelessly. It should not be allocated at the last minute, whereby the judge is deprived of the opportunity to give it its best attention. In my view, that judgments get reserved, particularly where there is not sufficient time in preparation. And with sufficient time, Deputy Chief Justice, is not days or months, but it is most certainly not 5 minutes before a matter has to be heard. 7, the issue of delayed judgments in our division is something that is very disturbing to me. Any good leader will attend to this first because of the sole reason we are here to serve the public as judges. We have a constitutional mandate to do so. An analysis of the Office of the Chief Justice report here in September 2022 will reflect that we have 19 judgments on that list that's outstanding for more than 6 months. Some of them go back to 2012. Still not...
2012?
2012.
10 years ago.
Yes. 2012. We also have 25 judgments that have been delayed for a period between 3 and 6 months. Now, the non-delivery of judgments has a direct impact, in my view, on the confidence that the public has in the judiciary. The issue of reserved judgment is not an insurmountable challenge to overcome. What it calls for is strong leadership, and whereby the norms and the standards of the Office of the Chief Justice need to be enforced. With that, I say that, of course, any judge president will not just storm in and reprimand a colleague and report them. You will analyze the situation, but for me, judgments not deliver show a lack of compassion to the greater public, and also just simply disrespect to the litigants. We are here to do a job, and one of that is they entitled to an outcome of a case. I'm not, in this regard, I'm not a leader that believes in a reactive leadership style. I always believe in being proactive. My whole track record in the years of leading staff, you can have more success by being proactive and by planning. So in my view, if we have a performance committee, and these things I say as my vision, I can't just say that it will happen tomorrow should one be so fortunate to become the judge president, but you will discuss this with your colleagues. A performance committee can assist you and analyze and look at judgments that are reserved before they become a problem. And accordingly, by being proactive, you will avoid the embarrassment of sitting here and saying, my division have judgments outstanding almost 10 years. Very close, and maybe that's the teacher in me that speaks. The transferring of skills in any division is very important. Particularly since you're the judge president, when you design, and what I've done in the past in being the senior civil judge does the same. You run the division in the absence of the judge president or the deputy judge president. You're doing all the work, and you're also receiving all the flack that they normally will receive. Now, the way you transfer is by allocating work and distributing work to the younger judges. Make sure, and younger judges, I simply mean judges that have not been on the bench for as long as the others. Make sure that they've been led by colleagues who can finally teach them. And this is not a formal teaching, but you learn through the process of osmosis. It's done in that manner. I've learned from many experienced judges, and I'd like to say that other judges have learned from me at times. When you show them how to write a judgment, you assist them. That's how you transfer skills. The issue of case management is an issue I think that we're all very familiar with. Case management and case flow is here to stay, and I have a lot of good things to say about that. For me, you should just monitor that, and you should improve on the system that we already have. We have a very good team in KwaZulu-Natal, a support team in dealing with case flow, and it's definitely brought us benefit. And I think it's all to the advantage of the public. The modernization of our division in the way we work, well, at least I can say that all of my colleagues in KwaZulu-Natal, we're all computer literate, but we don't have a modernized system because sadly so, we don't have access in both of the centers to internet. In Maritzburg, there is a half-baked access, but in where we are presently in the Durban Magistrates Court, there is no access unless you yourself make sure that you have some access in one form or the other. So we cannot move forward. We're always lagging behind. And this is something that I think needs to be addressed as soon as possible, so that you don't have one province that is the stepchild of the judiciary. KwaZulu-Natal is big enough and should not be the stepchild. We're entitled to be treated like all the other children. The 11th kind of vision, and forgive me if I have a long list, in fact it's much longer, I've condensed it,
All right.
is I feel very strong about a formal mentoring program for specifically for acting judges. I have designed a mentoring program at UCT as a law lecturer. We had great success in having lecturers that mentor students, as we refer to the mentees. And ultimately, if we have, and I say this because presently we attract judges from different backgrounds. Not each and every acting judge have practiced in the High Court. Not each and every judge has been familiar with the practices in the High Court. And for that matter, if you have a formal mentoring program, you will ease their time in when they come onto the bench, and at the same time, there would be an informal teaching between the mentor and the acting judge. I do not foresee any problem in designing it, and every judge that is a mentor would be able to advise the judge president as to the competency and capability of the acting judge. The pool can just grow, and we will eventually have a far greater pool to choose from. If I'm permitted to just have one more vision.
Yes, yes.
I know that you've already run over time, but again, sometimes you have to dream, and I believe in dreams that can come true. We don't have in our division a dedicated family law role. Now, the plight of women and children are close to my heart. And again, this is not something that any judge will just impose on his colleagues. You will have to discuss and debate it. There may be opposition to this very idea that I'd like to have. But if we have a dedicated family law role, then most certainly the cases that involves children in particular will be prioritized. It should not be up to the senior civil judge or the judge president or the deputy judge president to grant preference in a matter, because access to justice means absolutely nothing if that access to justice is delayed. That would be my vision in short, Deputy Chief Justice. As I say, I have many other, but I will stop here.
Yeah. That sounds like a terrific plan, I must say.
It's a long-term plan.
Yeah, well, let me just understand a few things quickly. You said, the very first thing you said was that whoever is appointed will have to work hard to reunite us. What do you mean by that? Are there
I think one needs to be...
divisions now?
No, I don't think that we are not united, but there is definitely a lack of team spirit. And for me, I've always strived to have team spirit amongst previously the staff that worked for me, previously even my council members. You can't move forward if you not all have the same goal and not striving to make a success of the division. You can also, I think where the problem lies is if we have a lack of consultation and a lack of meeting with each other, then you have these pockets that are doing work, but there's no team spirit. I've tried over the years. I know there's some of my colleagues that will crucify me because they're independent and they're not team players. But I believe that with a team spirit, you are just so much stronger than working in isolation.
Of course. And may I ask, why have you not had a judges' meeting for almost a whole year?
Why have I not?
why have you not had a judges meeting for almost a whole year?
Well, I cannot answer that question, Deputy Chief Justice. That is up to the leadership of the division to make sure that we meet on a regular basis. That's one of the things that a good leader do. You meet with people, you give them an agenda, you have your points, and you debate the issues.
But the leadership of the court is just, is just one of the judges. He's chief among peers. Judges are fully entitled to demand a meeting if they need one. Why have you not asked for it?
Well, I can say that there are emails to that effect where that has been stated in writing. This particular topic is important enough because it impacts directly on how we perform as judges, and we need to have a meeting. I think the response was that I'm not going to enter into a power play debate. So in that regard, Deputy Chief Justice, you cannot take the matter any further.
Yes. And you have a plan about improving the manner in which acting judges are selected. I imagine that what you suggest does not happen. The manner in which it is done is not optimal.
No, it has not happened. Let me elaborate on this. I serve on the committee of the acting judges. In the beginning of the year, shortly thereafter, we met and we decided that we need to revise the criteria for acting judges. And there's a reason for that. We need to be transparent. We need to tell, when anyone is asking us, why have you not invited me to come and act? You need to say, well, do you meet the criteria? Have you been in the profession for longer than 12 years? Do you have a good standing with your profession, etc., etc.? So it took quite some time to draft that criteria. And the next thing that was then clear is it's chaired. This committee is chaired by one of the other senior judges, Judge Pillay. Was that there was already a document sent out to the professions, and that one cannot tell the leadership how to deal with this. So this is very important. I think we have committees for a reason. That is not infringing on the prerogative of any judge president or deputy judge president. It is simply to assist and them in their task. That is what it is. So yeah, the criteria that went out was not the criteria that we've all discussed, debated, read the Bangalore principles, etc. This wasn't, yeah.
The issue of delayed judgments that you mentioned is the most concerning, and you spoke about enforcing an equitable, fair, and timeous allocation of work.
Yes.
And you mentioned something which you all know is true, that if you give people work late, then they don't have time to prepare in advance, and if they go to court blank,
Yes.
Blindly, then it means they are going to have to read the record after the hearing, and it's going to take time to get a judgment out. Is that what is causing these delayed judgments in the division?
No, I don't.
That work is not being given in time?
Sorry, Deputy Chief Justice. I don't think all of those that are delaying judgments can claim that. I'm simply saying that by being proactive, if you give judges sufficient time, then they would be able to be ready and deal with the matter. I don't ascribe to a method where a judge is sent to court without having read a file, without being able to engage with counsel as to what is this matter all about. That is embarrassing for the judiciary, and we should not operate like that as judges. But what I do think is what has been done about all of these outstanding judgments, and why have they not been delivered? I have, at the time when I served in other divisions, I have had the opportunity to serve under 8 different judge presidents. And I have learned a lot from their leadership. I've also learned a lot what to do and what not to do. And I most certainly think that where a good leader sometimes will take a judge after you've given him or her a complex case for a day or two out of court so that they will be able, when things are fresh in their mind, write it down and move forward. That way, you sort of make sure that judgments get delivered sooner rather than later. I don't think it's justice when you wait so long for any decision to be made.
Of course. Oh, well, let me stop there, otherwise we'll take all day. I just want to bring two things to your attention before I hand over to the rest of the commissioners. One of the law bodies, the Law Society, has made an observation about you, which is not positive. They say you have not enhanced the spirit of collegiality amongst your peers and members of the legal profession who've appeared before you, but there's no detail. Do you know what that is about, and do you have a response?
Deputy Chief Justice, let me respond. I think it reads something that we have been advised. There is no detail, there's no substance in that allegation. In fact, in the 42 years that I have worked from the age of 18 till now, I have never been accused of someone not being collegial. My chambers at times being considered a central station. Colleagues are always flocking there, asking for advice, going away. I have good relations with all of my colleagues. So I was deeply hurt, but also stunned by a hearsay allegation. In the 15 years on the bench, there's never been a complaint about me to this commission. No, I'm lying. There was one complaint I forgot one complaint. That was a prisoner, Mr. Christmas, who said that I should have not dealt with, I should have made known that I cannot deal with a matter where I was the second respondent because it was the National Council of Correctional Services was the second respondent. And of course I could not deal with that matter. And I've alerted timelessly the Judge President, I cannot deal with this matter. I'm second respondent. I know everything about Mr. Christmas, and the matter was not reallocated to anyone else. And on that day, I had to inform him that I cannot deal with this matter. So that was the one and only complaint. But never, ever has anyone, I've never been complained about to the Judge President. As you know, at times we as judges, especially when you're strict in your court and you're firm about certain things that should happen, the people will go to the Judge President and complain and say, I did not like the way that Steyn treated me today in court or whatever. I've never once had a complaint like that. I'm sitting here not knowing what that statement is all about.
All right. Lastly, the BLA has written a very complimentary comment on you, yes, and glowing terms about your leadership at the NCCS. But then they say because you have not acted either as the Deputy Judge President or Judge President in this division, or anywhere, I suppose, they don't support your appointment at this stage and, would rather you had an opportunity to act first. Yeah. How would you respond to that charge?
Can I just respond as follows, Deputy Chief Justice? You can only, first and foremost, act in the position if it is decided by the person who is in charge to put you in that position. So that is my first comment to it. But the second comment is that as the senior civil judge, you are the de facto JP or Deputy Judge President. You're either in Maritzburg or you are in Durban, and you are in charge. You draft the roster, you allocate the work, and you stand in, negotiate with the staff, you do all the work. So I think it's simply because they look at the title, but they don't look at the experience of whether one had any exposure to that kind of work of leading the division.
The previous candidate mentioned that you have judges' committees, that look into the running of the different facets of the division, which she said have not been active. Have you participated in those when they were active?
Active in what manner? Sorry, Deputy Chair. I didn't listen or to my previous colleagues' interview.
No, I was just saying, she mentioned that you have judges' committees, which is usual in all judges, in all divisions of the High Court, including the FCA, that you'll have a finance committee, a housing committee, and so on, where judges, they take initiative in the running of their own court. But she said that yours, and she supposed because of the disruption caused by COVID, have not been active in a while. Now, I wanted to know, because I know that one gets administrative experience from their involvement in those committees. Have you had an opportunity to participate in them when they were active, whenever that was?
I've participated in many committees. I've been chairing the budget committee, where you have in-depth insight into the cost running of the division. I have also chaired the research committee, where you have to evaluate and appoint researchers to the division. I've served in as I've indicated, the acting judges committee, but moreover, I have been, and that is post-COVID. So the statement is not quite correct. Let me just say that post-COVID, the decamping or decanting, as the Office of the Chief Justice have listed as committee, had met on numerous occasions. If it wasn't for those meetings and pressing for the needs of judges and what will be required in the new building, then we would have been even worse off than what we are today. I'm pretty sure that the JSC knows that the Durban High Court is presently renovated. So in order to move the Durban High Court to the Magistrates Court, we as judges had to meet on a constant basis, and we were in this committee was Judge Kruger, myself, Judge Wyatt, Judge Olsen, and Judge Khadebe. We had to give our time and efforts to this and ultimately draft long memorandums with the assistance of Judge President Mlambo, who assisted because our JP at one stage withdrew and he didn't want to serve on this committee. And we had various run-ins with the Department of Public Works, with the members of the Office of the Chief Justice. I think the last time two of the CEO and the COO had told the staff not to let the liaison committee, as they then reduced us to, be informed of anything that's going on for the judges. So essentially, this is why we're sitting here today, and there are only 14 chambers for the judges on the ground floor and 4 other chambers on the 12th floor. We are split, and it leaves us a disjointed sense amongst us judges. Also, if you look at the list of judges and you look at who are the 4 judges that are most junior, they are now separated. It's almost like a segregation. Which I definitely do not ascribe to, but it is because our views were not taken on board by the powers that be, and eventually this is where. So yes, that committee has still been very active post-COVID. In fact, we have been to sites, we have put in a lot of work, and I think that knowledge is very important in taking the division forward, because we will have to move back to the High Court. And who will know? Who will have the institutional knowledge of what is going on there? I can tell you that 3 of my colleagues on that committee will by then be retired, and because they will soon retire. And that's where that knowledge has become very important in how we operate, yes.
So in sum, you have actually been involved in the running of your court?
Yes.
Thank you very much, Judge Steyn. Judge Mngadi?
Thank you, Deputy Chief Justice. Good afternoon, Justin. We have met outside before you came in and we greeted each other.
Good afternoon, Judge Ngadi. We did meet indeed.
Thank you. Well, maybe before I ask some of my questions here, I'll just, you have mentioned a number of things.
Oh, I'm sorry, Judge Mgadi. We are going to impose the same rules that apply to the rest of the commissioners. Only 2 questions from you. And that goes for Commissioner, she's a commissioner while she's sitting here, Commissioner Smelane as well. 2 questions for everybody in the room. You've been warned. Carry on.
So my first question, Judge Steyn, will refer to the things that, according to you, they seem not to be attended to in the division. I'll mention it
Sorry,
just to finish.
I didn't hear the first part, the things.
The things that, according to you, they appear not to be in order or not being attended to in the division. I will mention those things, make a comment. That is my observation relating to that issue, and then I'll move on, not allowing you to comment on that because I'm allowed only 2 questions. The first thing, you talk about reserve judgments.
Yes.
My understanding of this is only that out of about 28 judges in the division, is only about 3 colleagues who are having a high number of reserve judgments. And secondly, I am well aware that even the previous JP, or even the JP before that, made a lot of effort to put pressure on these colleagues to deliver their reserve judgments. And I'm aware that, although I'm not certain, but at least some of those 3 colleagues, they have already been reported to the Judicial Conduct Committee for failing to deliver those long-standing reserve judgments. Secondly, you refer to the issue of no meetings being held. Firstly, I'm well aware that because we have got 2 sort of divisions, Pietermaritzburg and Durban, so there are logistical problems in arranging a meeting of all the judges. And the standard practice is that in each and every December, there will be a meeting of all the judges. In the interim, it's only if there is an issue which is urgent and which really needs that all the judges, they should be called in one and the same meeting. And again, in these meetings at times, as we pointed out, there are issues of other colleagues abusing those meetings, power plays, and all that, no progress being achieved by calling a meeting. But the current, even the previous JP, and the current acting JP, they have got an open door policy. If he is in Durban or in Pietermaritzburg, you can walk to his chambers at any time and discuss openly with any issue you want to discuss with him as a judge. You are given respect and he accepts you. And again, on each and every issue, he communicates with all of us, the judges, by email, and even give us time within which to respond or make an input. So that is indeed being attended to. And then talking about judges, if you say there are judges who are permanently appointed, but they need to be guided to write judgments, I don't know what you are referring to. Then you talk about team spirit in the division. Again, I'm not sure what you are referring to, because by nature of our duties, we as judges, I will only work with you on a matter if I'm sitting with you and we are dealing with those matters. Otherwise, I'm not sure exactly what team spirit you are referring to, but I regard myself as a junior judge in the division. I can communicate and discuss a matter with any judge, even the most senior judge. And if I'm sitting with him, I can dissent if I'm dissenting in his matter, and there will be no ill feelings. And again, amongst colleagues, even previously, I pointed out that, in my view, there is good working relationship between senior and junior colleagues. So I don't see any problem. I don't know what team spirit you are talking about.
Is that Commissioner Singh?
Sorry,
Bernard?
it's Commissioner. Barnard, sorry to interrupt, Judge Magaji. Is there a question going to be put to the candidate? Because we are late in the day already. Please.
No, there is a question at the end of what, after I've pointed out, relating to what she raised. And then I move on. We are talking about the Acting Judges Committee. This committee, my experience is was acting as a gatekeeping exercise. Whereas the leadership of the division, including the previous JP, they tried to open it up in the spirit of transformation in the division, that they must consider even candidates not recommended by this particular committee. But they did not ignore the committee totally. They still took into account what was recommended by the committee, but the committee felt that they had a decisive decision regarding who is supposed to be appointed as an acting judge, which indeed, in my view, that was completely not correct. And then,
Judge Mngadi,
and then
would it be
referring
safe-
to the issue
Judge
of...
Judge Mngadi, would it be safe to assume that you dispute everything this candidate has said? Because we really don't have time to go bullet point by bullet point through everything that she
But
said.
I can't understand it, Deputy CJ, because she was given a chance, bullet point by bullet point, to go through all these points. If I, on behalf of the division, am not allowed to respond to that, and then I can't understand what is the use of the exercise.
What is the question? Because I have yet
But I'm
to hear a
responding
question.
to what she raised as issues relating to the division. And I'm about to
We-
finish.
ki-
If you can
kindly
allow me
ask-
2 minutes.
Kindly ask a question of the candidate, because up to now you have not asked a question.
Thank you, Judge Steyn. And then again, you refer to that matters are not given to judges on time, which result in reserved judgments. Again, I don't know what you're talking about. Because if it's an opposed application, I receive the file about 10 days before the date of hearing. And if it's a matters which are on the motion court roll, I receive the files about 2 days before the date of the hearing of the motion court rolls. And again, you talk about the liaison committee relating to the renovation of the Durban High Court and relocation to the Magistrates Court of the judges. I was involved in the process, and in fact, it was driven by the leadership of the division, in particular Madondo. The liaison committee, they were resisting the relocation. They were raising a long list of issues, and then that's when it came to a stage that the leadership decided that in order to have progress in the matter, then all these concerns, a long list of concerns raised by the liaison committee, they should not be attended to. And then even now, as we are talking about, that renovation is in progress in Durban, and in maybe in about a year's time or so it will be completed. I don't know whether you then want to make maybe a comment on that before I move to my second question. No. In fact, I have not been allowed to answer any questions.
Judge Steyn?
Thank you, Deputy Chief Justice. If I may, in short, respond. The last question, well, two of the things. Judge Mngadi is referring to as to what the Acting Judges Committee wanted and what the acting judge president had said. As far as I'm aware, and that is in written communication, is that an email was sent by the acting judge president to the chair of the committee. Judge Mngadi has never been part of the acting judges committee, and most certainly have also not been part of the communication. So I'm not aware whether he's in possession of the email, but of course, I'm a stickler for rules, so I have all correspondence here available, and if need be, I will read exactly what has been stated in there. That's the one issue. The second issue as to the liaison committee, and I assume that Judge Mngadi respectfully is referring to the decamping committee. Let me also just say that the Judge Madondo was quite willing that Judge Mlambo, as JP, could assist us in all of this. In fact, the whole impasse came because Judge Jappi was not prepared. and let there be
Just
light.
give it a minute, it will come back.
Thank you. May I proceed?
Not yet. We need to make sure that the commissioners on the virtual platform are also on.
Okay.
We are here, DCJ.
You are?
Yeah, I hear.
Then carry on, Judge Steyn.
No, we hear.
Okay. May I proceed with
Yes,
your
yes.
permission? Thank you. The issue is, and I need to be very pertinent about this, and with respect to my colleague on the right, he was appointed in June 2018. That's the time when you were appointed. As for indicate you, one of the things that a member of your team will do is walk up to you and say, Judge Mngadi, I've noticed that none of your decisions are reported on SAFLI, and you are going for your interview to the JSC. It's important that they can read your judgments. That is a kind of team spirit that I'm referring to, where you assist your colleague, where you help your colleagues, and where these things have then been dealt with. But I want to go a bit further than that. And that is the fact that meetings are abused. Since January 2009, we've always had, usually termly, orderly meetings. We've had agendas, we've had minutes, unfortunately, that fell on many of us females to be the minute taker. And these meetings have never ended up in any division. In fact, we talked frankly and we debate the issues. That's what lawyers do. We debate issues. Those are the things. I'm sitting here with the last meeting and of the 3rd of December 2021. That is one which you did not attend. And the decisions all relate to the work we do in the division. So meetings are important. It's not a matter of dealing with going to a senior colleague or the deputy judge president or the acting judge president to go and ask for advice. It is sometimes things that need to be a collective to decide. But you've now raised the issue of you've always received your opposed motions timelessly, at least 2 days. Of course it has to be given 2 days before it. But recently in this year, will it surprise you, Judge Mngadi, that by 5 to 10, I've received an opposed motion. The council were already waiting in court, and it was never allocated to me on the Friday afternoon, never. So what can a judge do but walk, and that simply is by running your division. You need to be proactive. You hand out these things without embarrassing your judges. It is not a difficult task. I've done it so many times in my life. So I believe in the paper trail. So I have, again, also the matter. It was the 22nd of March. I have the case number, the counsel, and what happened in court. So, yeah, if you were so fortunate to always receive it on time, let me just say that there are a number of judges who were not so fortunate.
Thank you, Judge Steyn. Commissioner Simelane?
Thank you very much, TCJ. Good afternoon,
Good afternoon,
Judge Steyn.
Commissioner.
I will try and save you time, maybe just ask one question. Judge Steyn, in your understanding, what is your understanding of the term transformation of the judiciary or transformation of the bench, which is often used quite loosely between the organization, your BLA and NADEL? So firstly, please explain what is your understanding of the term. And as far as you know, as my second question, is our division transformed in light of that definition? Thank you.
Thank you, Commissioner. Let me just start off by saying that my understanding, so please forgive, I'm going to give you my understanding. My understanding of constitutional transformation, first and foremost, it's not an easy question to answer, Commissioner. What I understand as transformative constitutionalism is infinitely more than a question just a question about race. Our Constitution recognizes the reality of all of the where we come from in the past, and so restructuring and transforming the judiciary should be aligned to the values of the Constitution. That will be my first issue to raise. So, any judicial system that holds sacrosanct the values of equality between the sexes and also race will not discriminate against any group regarding that. Section 9 of our Constitution guarantees equality and prohibits race or discrimination. And coupled with equality, Commissioner, is that concept is deeply rooted in the concept of human dignity. I will acknowledge this. I will also acknowledge upfront that in the past, citizens in this country were denied human dignity, and it caused severe hardship. However, bearing in mind, in 2022, with our democratic order, with our Constitution, a policy that will never allow a particular member of a particular gender or particular sexual transformation or a particular ethnicity group to discriminate on that basis will offend against our Constitution. You've asked me whether our division has been transformed. At the moment, most certainly, if you look at the number of women on the bench, then I've indicated that we're still lacking behind. There are more men than women. When you look at the racial composition, well, since 2009, I've been the only white woman on that bench. There is, again, more of my, if you look at the Indian and African, and I think as sisters, we don't really look at that because then we're immediately busy counting little blocks. Our division is most certainly transformed in the manner that we consider the human dignity of those that appear before us. So transformation is not simply a matter of looking at and ticking certain boxes. It is by far more than that.
Thank you, TCJ.
Right. Commissioner Nyambi?
Thank you, DCJ. Afternoon, Judge Steyn.
Good afternoon, Commissioner.
You are aware that we have interviewed two judges with solid experience like you.
Yeah.
What qualities do you possess that will put you in good stead to triumph over them that we must seriously consider?
Okay. I thank you for the question. My qualities lies in my leadership ability and my track record of leadership. As indicated at the onset when I listed my vision, I didn't get the opportunity to explain to you my leadership qualities. My leadership qualities is I've been a leader since a very young age. I've been the head girl of my school. I moved into the Department of Justice. I've moved through the ranks of it. I've been a senior a magistrate with lots of experience, and then a senior prosecutor, and later on also in my work at UCT. I've been recognized by chairing various committees. I've been the chair of and mood coordinator. I've been serving on the appeals court of the university. I've served. So my leadership qualities are really developed for a long time. But one thing that I have not shared and had the opportunity to express to this commission, because I haven't given a presentation of it, I have served on the Jolly Commission as a commissioner, investigating sexual harassment, maladministration, and corruption. And in the commission itself, which was very difficult, I have, my leadership skills have been honed. I have served under Judge Jolly, who has been a great mentor and has guided me, but moreover, I have developed over time, and when I moved to the KwaZulu-Natal division, my judge president, Shabalala, at that stage when I was appointed, was way ahead of his peers. He empowered women long before it was good to do so. When I arrived in KwaZulu-Natal, shortly after I've arrived in 2011, he asked me to chair the forum, and let me just say it was called the Provincial Integrated Justice Forum. It was a precursor to the Provincial Efficiency and Enhancement Committee that we have now in terms of the Superior Court Act. I've chaired that. All the stakeholders that are presently in the PEC were all represented at that forum. Eventually, by the end of 2012, I handed it over to Judge Jappi because I was allocated and assigned a very difficult criminal trial. And soon after that, the Superior Court Act came into operation and things changed. So the leadership qualities I'm bringing to this division spans over literally more than 40 years. I have excelled at UCT. You don't normally, and it's not a few, I think there are a few of you that are from the academia, would understand that in order to be bestowed a prestigious award like the Distinguished Teachers Award, it is an award that gets awarded across the disciplines of the university. And they consider and evaluate you about what you had brought to the curriculum, what leadership you had showed that went beyond teaching. So I have done all of that over a long time, and I most certainly have done so also in the time when I acted as senior civil judge in KwaZulu-Natal.
My last question. I listened to your vision, and before I can conclude that I got lost when Judge Mgadi raised the counter view. So if you can share with us your best and worst moment as a judge in KwaZulu-Natal High Court Division.
I was really hoping you wouldn't ask me that question. I think the worst experience in KwaZulu-Natal was losing a very dear and near colleague who sat here in front of you in 2016 to become one of these leaders, Judge Nguni. I think the shock and horror in the division when of his untimely passing last year in September left us all with a sense of grief, particularly because the wellness of judges ought to get more attention than what it is presently getting. That for me was the worst. As for the best, I think for me the best is when staff members, and I'm not speaking of people with important titles, come to me as Ma and sit and look at me to assist them in doing things, empowering them to study further, help them with their assignments. Those times are far greater than any other accolade that may come your way. I'm a very simple person, and I really get joy from those things by serving people more than anything else.
Thank you, Judge Steyn. Thank you, TCJ.
Thank you, Commissioner. Commissioner Matolo Tlepu.
Thank you very much, Deputy Chief Justice. Good.
Oh, sorry, yeah, it is actually your turn. I called her out of 10. Carry on, Prof.
Oh, thank you very much. Good afternoon, Judge Steyn.
Thank you, Commissioner. Good afternoon.
I have two questions for you, but let's start more with a more substantive one. And I'm asking this in relation to your experience at the magistracy and as a prosecutor,
Yes.
as well as I saw that there's a judgment that you penned some time back. I think it's Naidu versus Chetty. I'm not sure if you still remember that, dealing with domestic violence, but it's fun. I wanted to deal with that, but anyway, if you don't remember it, let's ask it more broadly. In practice, there seems to be a manner in which magistrates, in particular, deal with domestic violence cases, where they issue interim orders, and of course later on they confirm them. And some of the orders that they provide will be that the alleged perpetrator should actually be removed from the complainant, right? And you might find that the perpetrator and the complainant are actually residing in the same place. I just want to hear your view, whether is there any conflict in relation to how the domestic violence is actually carried out or implemented with the right to housing of the people who are actually being evicted without an application for eviction being brought to them. Is there any conflict there? And if there is, how can we resolve this issue? Because on the one hand, you want to make sure that the complainant is safe. But on the other, to keep the complainant safe, one of the ways is to remove the perpetrator. But the perpetrator also has constitutional rights to housing, not be deprived of their home and all this. How do we resolve that particular conundrum?
Thank you for the question. I think there are various cases which we can focus on of domestic violence where the perpetrator has not been removed, and we ended up with a person on the other side that passed on, because the violence escalates to the point whereby women get killed, and I say women because it's mainly women who are at the receiving end and are the victims of domestic violence. It is a very difficult question to answer, because you are dealing with two competing rights. Do I consider the right of the person that has to be removed, or do I consider the right of the wife and the children? And which of these two rights will trump each other? For me, it really falls down on a practical level to the safety of the family first. But I also, in the same breath, would like to say to you that we see sometimes when there are interdict applications later on, and you hear that there was a previous domestic violence order, you will finally see that the problem that you have is that it also gets abused. We are busy with a divorce action, and one of us want to benefit from this. So it's not, in that regard, I do think that there are various NGOs that do great work, and it is really a socioeconomic problem as to how we address that. There is no easy answer. I'm sorry.
No problem. Something that is really in my head as well. But I appreciate your answer. The second question that I have for you, when you were stating your vision, you sounded to me as a person who has a lot of complaints with what is currently going on in the division. And I'm not saying that you have. I'm just saying the way I perceived what you said. I just want to ask, because the thing is, there are two leaders. Well, both of them, they are actually on an acting capacity, right? The people who are making the leadership crop. Do you believe that these two leaders are bad leaders, and they have not done what is supposed to be done to address some of the concerns that I thought came out from your vision? Not having meetings and all those things that you mentioned, that your colleague on the right wanted to respond to.
Let me first and foremost say, when I articulated my vision, It is not an indication of a complaint session at all. It is the vision I, as a leader, have for KwaZulu-Natal. I would do certain things differently. So the way to deal with one's vision is to say, here is my plan, this is what I will include in my plan, and if I ever come back to you, I will say to you, I either had success or I did not have success. So no, if that was the way it was understood, I want to categorically state here that this is not meant. I'm not here today to criticize any of my colleagues. That will go against the harmonious work that we can do as a team, and that will go straight in line with what I say, that one has to have a team spirit. So no, there's no complaints. In fact, in 2016, I've assisted Judge Madondo. We had mock interviews in my chambers. I've reached out when he asked me to help him edit the traditional court book. You will see there's a thank you note for what I did. I have nothing against either him or Judge Poyer. In fact, Judge Poyer and I have always been good friends. Yesterday, we were on the same plane. We were taking selfies when we landed. So I literally have a good collegial relationship with both of them.
No, thank you very much, Judge Steyn. Thank you very much,
you.
DCG.
Thank you, Commissioner.
DCJ, follow up, please.
Yes, Commissioner Bernard?
Thank you, DCJ. Judge Steyn, you earlier mentioned that that by the one incident whereby 5 to 10 you received an appeal motion just before court, and in other words, in short notice. Now that specific problem is clearly a problem for you. Did you take that up? That sort of trend of allocating the judges, matters with short notice. Did you take that up with any of the two leaders to try and sort it out so that it would not be a problem here today?
Thank you, Mr. Barnard. You're referring to two leaders. There was only one leader when it happened. I indeed was looking for the leader on the day that it happened, and by the time I went to the chambers, he was not there. I have taken it up, indeed, so it's a known fact. Previously with Judge Madondo, when he was still very young as the Deputy Judge President, I remember very well, I was in motion court on the Wednesday, and the Monday afternoon in Maritzburg at 4:15, I left 4:30. His secretary called and says that you have an opposed motion for tomorrow. And I said to her, but I am in motion court on the Wednesday. And so the Tuesday I went to him and I said to him, we cannot work like this. We should receive things timelessly. And this is what happened. And he says, Esther, it won't happen again. So we've definitely talked about it. And I want to assure you, I'm not someone that bear grudges. I deal with the issue straight on. I believe that this is the way to resolve conflict, is to rather talk to your colleague than wait until it explodes in a big thing.
Thank you, DCJ.
Thank you, Commissioner Bernard. Commissioner Matolo Lepu. Oh, sorry, Commissioner Moimang.
Thank you, Deputy Chief Justice. Just two from my side. The first one relates to one of the judgments that you have referred, Judge Steyn. Good afternoon.
Good afternoon, Commissioner.
Yes. The first one relates to one of the judgment, State versus Zuma. And then the second one will be the matter of the acting policy.
The acting policy, sorry. I did
Yes.
just, yeah. Okay.
How did you resolve the three areas that were identified in this matter of Zuma, where three issues were raised? The issue of the NPA having acted outside the scope of its powers, and then two, having acted in breach of the NPA prosecution policy.
Sorry, I didn't hear that. The NPA policy, yes?
Yes, and then the third one, that their decision was irrational. How did you use the values enshrined in the Constitution, like the rule of law and also the supremacy of the Constitution to maneuver around these areas? The second one on the policy, I just want to get clarity as to whether did you say that there is no draft policy that guides the appointment of the acting judges? And if there is none, what input can you give us to ensure that there is clarity in terms of guidance around the acting policy? Because I thought there was a policy adopted that was guiding the appointment of acting judges. Thank you.
Thank you. I will start with the first question first. It's always difficult to go back to your decisions that you have made, and particularly because we've made it also as a bench. But you would have noticed from my list of publications that I've been fascinated, besides my background, but how the new National Prosecuting Authority Act, the 1998 Act, will find application. And again, I've published with Professor van Zyl-Smit in critiquing the Act. So when the matter was argued, certain parts of the judgment, as much as we did that as a collaborative, we divided. And we've literally tried, and so once you write it as a court, as you know, particularly because here you don't have a scribe and then you have 4 judges concurring. Here you have the whole court. So the judgment remained the judgment of all 3 of us. So it would be very unfair of me to claim any part and try and explain anything. But I can tell you that if you look at the articles written, it was unfortunate for us also that counsel for Thales has also read this article that I've written in my previous life when I was an academic, and was constantly referring to this and making submissions, which literally placed you in an invidious position. But one has tried and balanced it. The undue delay of cases and whether there should be a stay of prosecution ultimately was the most important one in the Zuma matter. And then coupled with that, there were the aspects of whether Mr. Sean Abrams acted unlawfully when he considered to reinstitute charges not only against Mr. Zuma after the earlier withdrawal, but the SCA decided on that. I will call that the Mashe withdrawal, but also the position then as to how Thales now came back into the play. So under those circumstances, one have tried to balance the right to a speedy trial, but also the conduct of the NPA and the lawfulness of the conduct. And I'd like to say that we've worked through all of that and balanced all of that. Coming back to the issue of whether there is now a document regarding the criteria of acting judges, such a document indeed went out to the profession. I think the complaint, which my colleague on the right, Judge Mngadi, referred to, was the fact that that document was the document that was drafted not by the committee, but by the acting judge president. I have to say that the acting judge president, in his response, and I have to defend him here, he did say that he consulted with the acting deputy judge president, who's also a member of our committee. And that wasn't made clear to us. So I need to defend Judge Madonda in that regard. He did say in that email that he discussed it with the acting Deputy Judge President. I hope that answers it.
Thank you, Judge Steyn. Thank you, Deputy Chief
Thank you,
Justice.
Commissioner. Matolo, Commissioner.
Thank you, Deputy Chief Justice. Good afternoon, Judge Steyn.
Good afternoon, Commissioner.
You have applied for a position of Judge President, and I'm just thinking. I listened to your vision, as Commissioner Marumokha says. It was a bit of a inward looking about your division, what is happening. I just wanted you to tell me, for me to be comfortable, that your appointment will actually bring a difference to the province. Firstly, I just want to, because I see the GCB, they say, one of the things they said, you are very proficient in English, and KZN, the majority of people speak isiZulu. Can you do that? Can you speak isiZulu?
Is that the question?
Yeah.
Commissioner, let me just say that inherently language is a sensitive issue, and it is very much dependent on your environment where you grew up. I think only Commissioner Lucas will know where I grew up. I grew up in a small town place called Kennard in the Northern Cape. So I speak, in fact, English is not my mother tongue. I am very flattered by what the GCB says. I'm Afrikaans speaking. English is also my second language. I've also learned a little bit of because it was compulsory German for 3 years, but I can't speak the language. As for isiZulu, there need to be a desire also to learn the language, and that desire developed with me when my secretary, Tobeka Zungu, Ni Zungu Samalani now, started working for me, and I really wanted to learn the language. I've started off by having the great R books from isiZulu. I was not successful in that, and then there was COVID. And she has a lovely son who visits me at times, so I have now ascribed to a new program. It's called Duolingo, and I'm making huge progress. I could impress at least a 4-year-old with telling him about some of the animals and things, but I'm far from being proficient in isiZulu. But it is definitely my aim to do that, because every time I'm invited to functions where one of my friends have to translate to me, I want to know firsthand what he said, and I literally can't wait for the day when I can. I've now tried when people are greeting me in English, and I say, why don't you say to greet me in isiZulu, in my own province? So this is a work in progress, and I hope to at one day meet with you again and say, I can now speak the language.
Okay. A follow-up question. You know, KZN is a rural. There's a lot of. It's a rural. There's a lot of rural places, and one of the things why I would support you is for you to make sure that women in rural areas get access to justice. And from your vision, I haven't heard that much, that how are you going to bring access to justice to the rural women who really need it, not the issues in your court, but that's the reason that will motivate me to support you.
Thank you, Commissioner. Access to justice is paramount for every person. KwaZulu-Natal is a vast province. One thing that one should bear in mind is that the access to justice is already, if you look at the list of the regional courts, there are 76 regional courts in the province of KwaZulu-Natal. There are 4 more who are dealing with backlog cases. So the judiciary is going out to the people. Bear in mind, as the judge president, it is your duty also to coordinate the lower courts, and you have to liaise with the heads of the lower courts to make sure that there is access to justice. We have circuit courts that go out, but let me just be frank with you, and I'm not just listing any problems, but sometimes one must also list these things so that that can improve. Most of our circuit courts, and that's not putting blame anywhere, we receive this from either the Department of Justice or the Department of Public Works that are not doing what they're supposed to be doing. So you have a circuit court in Matuba, you have no water there. You have another circuit court in Scottsboro where the judge running the court will have to wait for the regional court magistrate to first finish his court before she can go and deal with the cases of the High Court. That is not access to justice. It has to be more. But I firmly believe that one has to go out to the people. We are here to serve the people. And the first thing is that if one is in charge of this, that you go out to these 76 regional courts and you also see whether there is not need for more. That's not infringing upon the rights of whoever is in charge of the lower courts. That is simply making sure that everyone has fair access to justice. So I'm fully agree with you, and this is also why I've referred to the family law court. Access means nothing to the people unless they have truly access to justice.
I could go on and on, but thanks, Judge President.
Commissioner Bernard, did you exhaust your questions?
No, DCJ, I have questions.
All right, go ahead, please.
Thank you. Judge, while setting out your vision, you stated the plight of women and children is close to your heart.
Yes.
Now, when there's litigation on behalf of a minor, and it's run for a number of days, if in mid-trial then there's this, the matter of recusal comes up, what factors should a court take into consideration, and how should the process unfold before the court makes a decision on recusal?
Okay. Thank you, Commissioner. You referring to a matter that is presently ready to go on appeal, since leave to appeal has been granted. So I will try and not say too much so as to influence any appeal court that will have to deal with it. Let me start off by saying how seriously I take the plight of women and children. When I joined UCT and had to decide on a dissertation, without hesitation, I decided on witnesses, the stepchildren of the criminal justice system, and I focused on rape victims and child witnesses who did not get what is be expected from them. So this is not something new that I consider the plight of women and children. It has been with me all my life, wherever I've worked. To be back to the matter, what was given to the matter in this particular case was just, in short, excerpt from the trial, which is clearly not indicative what happened throughout the trial. When one considers any recusal, and let me say this up front, in 21 years on the lower and high court bench, I have never recused myself. This was the first time that I had to recuse myself. And one reason why this is so important, you as a judge have to be impartial at all times. And if you look at the code of conduct very clearly, and also to the case law and the jurisprudence as it developed around it, a judge must recuse him or herself from a case if there's a real or a reasonable perceived conflict of interest, which wasn't in this matter, but a reasonable suspicion of bias upon objective facts. Throughout this trial, certain objections were made, certain things were said by the counsel, and ultimately it led to the point of, on this specific day, irrespective of who the plaintiff is, this plaintiff is entitled to have an impartial, unbiased person presiding in this matter. At least it should feel for the plaintiff. She should perceive that. And in this matter, once the final straw that broke the camel's back was when counsel stood up and after the objection say, the court will decide in favor of the other side. There was no pronouncement of any order that will be made. I've adjourned the matter. I've seriously reflected on the matter. I've discussed it with my judge president. I sought jurisprudential leadership. I discussed it with some of my senior colleagues. But none of that is their decision. I went back to my chambers, and I thought there's one way of solving this. Maybe if one offers to counsel to withdraw that, one can again restore the impartiality, at least for the party, the litigant. It will appear that you are still unbiased and impartial. Unfortunately, I could not salvage it. I offered it to the counsel, but he did not take it. So it's not clear to me whether you're aware, Mr. Barnard, that on the 26th of July 2021, a letter was received by my chambers. Have you seen that letter?
No, I'm not sure that I'm
Okay, can I quote to you, because this refers to the case that you've said, and I'm just going to quote without revealing the identity of the senior counsel, but this is what it says. Your judge recused herself, citing my conduct. Quote, that conduct has been the subject of disciplinary proceedings before the Society of Advocates of KwaZulu-Natal. I was convicted of unprofessional conduct. End the quote. So I wanted to say to you that this was something that went over days, and it reached the point where no litigant would believe reasonably that I'm bringing an unbiased mind. And it would not be fair to that plaintiff, because that plaintiff may very well be in a position where you should decide in his and her favor. This was a her, and it just didn't happen.
Judge, where I'm coming from is from the position of someone who's in leadership and is leading the court. And my question is going in this direction, in the sense that you adjourn the court and you come back into court and you make a remark, something like, does the counsel have something to say? But then what happens is there's without asking the parties to address you on it, a recusal is ordered. And that's the big question here, is when you're in a situation, even as a leader, even out of court, anywhere, and you have these difficult parties, and I'm accepting, even just on a short reading of that record, of the extract of that record, I'm accepting there's unprofessional conduct by one of the legal practitioners. But the point is this, is that before the court orders recusal, there's no opportunity for the parties to address the court, and there's a child involved. That postponement would probably created a delay of I don't know how long, and the child's rights can't be enforced, whichever way the court would go eventually. And then there's even legal authority for it that one should. There's I don't know if you're aware of the authority going back as far as 1952, which says the grounds of recusal relate purely to what happened in the course of the trial. Neither counsel has been able to find any reported case. I'm reading from a case, Black versus Silver, 1952. Neither counsel has been able to find any reported case in which an application for recusal has been made in the course of a trial and on the ground that the judicial officer has shown bias by his conduct of the proceedings. And this is not surprising, since the ordinary way of meeting any apparent bias shown by court its conduct of the proceedings would be by challenging his evidential decision in an appeal or review. So the point I'm just making here is, it doesn't seem to me that counsel on either side, whether it's the transgressing counsel or the other side, were given an opportunity to address the court even on this harsh decision, which created a tremendous delay in a matter which had been running for several days. So I'm questioning the ability or the way that this was gone about, and I'm relating it to a situation where you maybe as a judge president in a court where some difficulties could arise. There could be different arguments within your division, and you are supposed to play a calming role and so on. One of the basic principles, I put it to you, and that's the question, is to hear the parties on either side before you take any decisive decision in the way that you have.
Commissioner Barnard, I think no judge, particularly no experienced judge, will take this decision lightly. You're referring to the fact that here is a child involved. How would it be if the decision went against that child? The fairness and the impartiality that that child is entitled to it is very important. We must bring an impartial mind to the proceedings. Once that impartiality is placed into question, and the opposite of that is an unbiased mind. Once that has come into question, I have taught the law students for many years about recusal and how to go about recusal, and we have drilled SARFU into them over and over again, because all of it's the apprehension of bias. But let me not go to the cases of the 50s. Let me go to the cases of the Supreme Court of Appeal in 2009, Volume 2, SACR. I think it is the matter of State versus Dube, where the Supreme Court so eloquently stated that where one can that no longer bring an impartial mind, and that means that it will be based and it must be clear, manifest to all. Now, that manifestation, once your own counsel had said, you will decide in a particular way, it could not go any further than that. It was many recusal applications, and I don't know how many you've had, but in 21 years on the lower and the high court bench, I've had plenty of recusal applications, because it is a known fact that some councils sometimes will look for a different bench and in the hope that they will decide differently. So this decision was really a very difficult decision, and it did not matter that this matter was a child. For me, it was more concerning that it was a child. And if one decides against the plaintiff, that mother will never know where justice lies, because she had seen her counsel saying, Judge, you decided this matter already, and you know what you're going to do. And that is apprehension of bias in the worst form.
Commissioner Bernard, I'm just wondering if further interrogation of this matter does not, well, I actually think that you are traversing the merits. We are right there now, because here is Judge Steyn defending herself. She's even citing authority. We may be traversing the merits of a matter which she warned ahead is sub judice. She's given her explanation. Should we not just leave it at that? We can make of it what we will.
DCJ, the judge is saying that there was an application for recusal, and I do not understand that there was any application for recusal.
I didn't say that.
You were talking about applications for recusal now just moments ago, Judge.
No.
That's not what I heard.
No, Mr. Ban, sorry.
Yes.
I didn't want to be rude. I've interrupted you, Deputy Chief Justice. Let me apologize. I did not say, I've said many of the recusal applications that we deal with. I did not say that there was an application here, Mr. Barnard.
So there wasn't an application in this instance?
I've indicated it was a matter that required a mira moto recusal.
And you didn't give the counsel on either side chance to address you on that?
I've given counsel the opportunity to withdraw that. If it was withdrawn, it would have been the end of it. I've indicated that to you, Mr. Barnard.
Thank you, DCJ.
Thank you, Commissioner Bernard. Minister?
Thank you, DCJ. I just want to ask you with regard to your role in the NCCS. As you are aware, in the public, the parole system is being criticized. How do you think we should balance the restorative justice part and obviously the public criticism that in particular lifers do not deserve a second chance in society?
Thank you, Minister. Well, as you're aware, just shortly before you took over as Minister of Justice, I've organized a conference on parole and the policy surrounding parole. Parole is also, because I've published a lot of chapters on prison systems, and parole is something that is very important. I do understand that when we deal with restorative justice, there is a perception out there that once the prison door has closed, then that person should remain in a correctional center. And what is then ignored is the fact that through the rehabilitation, through the various programs, anger management, through the programs, the psychologists working with them, lifers also deserve a second chance. For me, perhaps and I'm mindful of the fact that judicial overreach shouldn't happen. I shouldn't make statements. For me, I think the one thing that we have not considered in South Africa under our prison system is when we have life imprisonment with parole and life imprisonment without parole. In State v. Sangweni, one of the decisions, my reported decisions, where I've dealt with the life imprisonment that replaces the death penalty, and in which instances we should consider life imprisonment. I think it is worthy of a consideration, Minister, but parole in itself have various facets to it, and whether a lifer is genuinely rehabilitated is one of the very important questions to ask. I know that we as a council have debated this issue for many times because lifers also deserve a second chance. And if they have done everything that you require of them to rehabilitate themselves, what more can you offer? But perhaps if we diverge and we have life imprisonment and life with parole and without parole, it may very well help to solve the problem. I've also like to say that in the Jali Commission report, we've made recommendations regarding parole. Those recommendations were not taken on board by the Department of Correctional Services.
Yeah, lastly, what has been your experience while you were with the NCCS of reoffending or the level
Recidivism,
amongst the lifers in particular?
Okay. Thank you, Minister. That was one of the issues that was also discussed during the parole conference. And if we look at the department, whether they have any statistics regarding recidivism, you would notice that they don't keep statistics of someone coming in through the door and the door being a revolving door and someone leaving the door again. So first and foremost, this is where we have to start. We have to look at which one of these prisoners come back. And I understand there is a tendency to say, but maybe we failed in the rehabilitation if the person is coming back. That shouldn't really be in consideration. I think that if we want to address recidivism, then we need to have proper statistics, like we have statistics in OCJ. And once you have the statistics, you can work from that and see, and you can measure your success in the rehabilitation.
Thank you, DCJ.
Thank you, Minister. Any further questions from the virtual platform? No. Well,
None from me,
Thank you,
DCJ.
Commissioner Singh. Well, we've reached the end of your interview. Judge Steyn, thank you so much for making yourself available, and go well. I'm not going to invite you to give a closing statement. There's just no time.
I just want to thank the Commission for this opportunity of presenting myself to them and for being here. Thank you, Deputy Chief Justice. Much appreciated.
Thank you.
Thank you to the Commission.